What are we doing when we see, Lindsay, stuff about carve-outs for sexual harassment come into policies about about which we're investigating? What do you do with that? It's not yours to enforce. You're a neutral when you're an investigator.
Right. I mean, from my perspective, it's enough that the policy exists, and I would hope in 2025, almost 2026, that that is the case. We are real careful as neutral third party investigators not to cross the line toward enforcement or recommendations when the client hasn't asked for them. I think on that, so that's like through the investigator lens. Like, I just need to know that the policy exists, and it obviously is sufficient enough by the time it comes to me to have enabled an employee to report that behavior and those allegations in some kind of form or fashion. But the sort of intervention solution side of me, the coach in me, also thinks about, and the culture side of me thinks about, like, how do we make sure that our employees not only know about our policy and what it requires of them in terms of their duty to report, but also, like, how do we implement that policy, and then how do we make sure that our employees are real familiar, because they are being given a duty, in this particular case. There's a lot of policies in a handbook that don't obligate an employee to certain behaviors, or require anything in particular of them, and are more sort of informational and educational in purpose. But when it comes to reporting concerns of any sort, especially the ones that touch on Title VII related matters, and sort of behaviors in the workplace, I really think deeply about, like, are we doing more than just having them sign off on a sexual harassment policy one time when they're first hired? How do we make sure that our employees remain aware of this obligation on an ongoing basis? And so that can be done through annual sign-offs, certainly sign-offs anytime there's changes made to the policy, and then also thinking about training.
Yeah, that's great. Okay, so then we're gonna go at this question backwards and kind of recover some ground here. So Lindsay needs to know if there is or isn't a policy. Lindsay's always thinking about how do we socialize things for awareness, actual real awareness in the organization. But Amber, are you actually seeing these documents come to you as handbooks that have like the have the inappropriate sexual harassment verbiage in there, or seeing employee agreements with arbitration agreements where they're not carving out the sexual harassment? Like, are we receiving bad documents that need improved?
It does happen, yes. And I think just going through them, these have to be updated because, like I said earlier, laws are just changing all the time. So, just making sure that I always recommend on a yearly basis to go through all of this at minimum to make sure. And like you said, now's the time. So to make sure, that all of those with the new laws that come out, are up to date.
That's right. And now is the time, Brian, because as a litigator, when you see that we don't have carve outs for our sexual harassment stuff, when we see it in our arbitration agreements, when we see, a lack of carve outs in our handbooks for sexual harassment, what does that do for you as a litigator, as far as a tool or sort of self-inflicted injury with our own bad documents?
Yes, it's funny because it's kind of like playing a game of chicken.
Mm.
It's whether opposing counsel realizes it or not, but you really are riding on fumes in this game of chicken if you don't have the carve outs, because you're not going to generally be able to go to a court for help, for enforcement. And many times the lawsuit's never filed, and it's that leverage from the document that is what gets the conversation started in a positive way, for our clients. So we definitely appreciate annual, every other year, review of handbooks.
Yeah, absolutely. All right, we're coming at this a little bit backwards, but let's backtrack. And Amber, I'm going to call you out again that this is headed your way because I always just adore the clarity that you bring to this topic. When you look at a handbook and an employment agreement and maybe other documents executed between an employer and an employee, or maybe an executive and an employer. How do you figure out what goes in the handbook and what goes in a separate policy? Because of course, I'm going to then ask Ryan the same thing. Like when we have a handbook or a policy with enforcement, like what do we do with that? But Amber, first to you, how do you make a determination if something should be within a handbook or outside of it?
So if it's going to, sorry, one second. The way I make a determination is if it's going to go ahead and be more contractual. So, as Brian said earlier, handbook is not a contract. So, coming back to things like non-solicitation, confidentiality, any agreements that kind of limit employees' rights somewhat, or change after their employment ends, because a lot of those things do govern kind of how they bring, if they're going to bring suit.
Okay. All right. Let's keep going. Let's keep transitioning. I want to talk a little bit about bring your own device documents. All right. So we're might as well be 2026. BYOD was a big deal during COVID when we all got sent home. So you would think everybody has fantastic BYOD platforms, but it's really hard, right? I mean, things we talk about even just within this firm is you had a cell phone when I hired you. Do you want to? You had a computer when I hired you. Do you want to? And we make, as a firm and as an employer, we make some decisions around that. But technology is chronically changing. Systems are changing now. Everybody's on AI. Um, Amber, I'll start this with you. What are you seeing in trends sort of at the academic and in the sort of institutional level, things we see in handbooks around BYOD in 2026?
So overall, high level, never want to get technical within the handbook, but you also at the same time don't want the employee to be surprised, right? So you just want to lay it out. What I really like to kind of put in there is a high level of what can be monitored, what can't be monitored. If they are using their own device, what kind of level of access the company has. So really just kind of giving explicit notice that monitoring will occur. And then how it will occur, and then what limits there are overall, but not getting too specific as well.
All right. So, Lindsay, let's go to you. So, I've got this handbook. It's got some stuff about BYOD. Again, not asking you to play IT, but
Sure.
what do I think about what employees are thinking about my handbooks and my policies and my BYOD situation?
Yeah, on this front, I think about like my own situation. I like much prefer to have everything in one place rather than to be like switching around from one device to another. And so I am appreciative that there's an opportunity to like use my own devices, but recognizing at the same time that can put employers in difficult positions if they haven't thought through the implications of allowing, because I think especially for small business, there's this tendency to think, oh, everybody's got access to technology, everybody already has their things, just bring it with you, and that's how you'll do work. But if you lose control over what's happening on those devices, and how employees are spending their time, as it relates to your work or not your work, there's some downstream effects. I think that if you're not real intentional about thinking through those things, can maybe get you in some hot water, and maybe Brian will have a better perspective on that in a minute. But as an employee, I think about things like, am I going to be compensated for the use of my own devices? What does monitoring look like, and how imposing is the employer going to be on, my use of these devices? And we actually just encountered this, Sarah, you had an issue with, I don't know, your Microsoft or something earlier, also not a sponsor, but if they wanted to, I bet Natalie, you'd be open to that. And because we're all using sort of different platforms and different systems, having support available to employees, I think, is like really essential, because each one of us come to work with varying levels of technical knowledge and technical capability. And again, like thinking about an employee, what kind of costs might come out of my, or as an employee, what kind of costs might come out of my pocket if I need support on making sure my software is working appropriately, or I'm not having hardware issues and that sort of thing. So I think being thoughtful about what kind of support you're going to have, or you're going to provide to your employees if they're bringing their own devices, is a really important thought process.
That's not at all what I thought you were going to cover, Lindsay. So let me ask you an extra question here.
Well, give me a hint where you want me to go.
Gosh, after all these years together, I feel like you should read my mind. So I've got a handbook, I've got a policy, and I've got devices, and I got work to do. How can I ensure that my employees are actually absorbing and have actual awareness of my policies and the
Oh, yeah. I mean,
expectations around
I'm
those
gonna
policies?
probably be a broken record on this, right? Because it starts with letting them know what the policy is. So, that can be through the handbook, can be through a separate signed document if that's necessary. And Amber will tell you if it is. And then training employees on how to comply with that policy, and understanding what their obligations are in terms of how they manage devices and interact with those devices in the context of their employment.
All right,
Broken
so
record, sorry.
no, it's great. I thought that's what I was teeing you up to say.
That's so funny.
All right, Brian, you always come in as the enforcer. Actually, Amber is the pre-enforcer, and then you're the heavy hammer as our conflict specialist. So if I have a BYOD device policy, I was redundant. BYOD policy, and it either is or isn't socialized properly. It either is or isn't implemented properly. But the point is, we got people on personal devices doing things they should not do. How do you look at that sort of in either dynamic, that we did it right or we didn't do it right?
Yeah, I think one of the major issues there is who owns the data, because I guarantee you the employee thinks they do. While if your policies are set up correctly, you definitely own the data, and they're by putting it on their phone, it doesn't change that. But when employees have their own device, they feel like what they're doing is theirs. So it's important to recognize that. And I see it a lot in smaller businesses. When somebody's exited, they have maybe all the passwords on their phone saved. And so you've shared the account, and now they've been fired for 2 weeks, and they're going in there and trying to get information afterwards. Maybe
Oh
it's
my
your
gosh, yeah.
customer lists,
Yeah.
like important information. So bring your own device policies are great. Put some thought into yours, and training, as Lindsay mentioned, is really important. But from a legal perspective, clearly defining that you own the data is essential.
Yeah,
What
I
are
think
the,
that's
sorry, go ahead.
real quick, Natalie, I'd like to add, I think that's so important because with my investigator hat on, Brian, I think about like the potential for sabotage. And because we do a lot of like separation work, we're always on top of like the access restrictions and those sorts of things. But employers don't, do this kind of thing every day in the way that we do. And so, or hopefully not anyway, right? And so having the technical expertise needed to prevent any downstream sabotage that could happen is like also a really important element. And maybe that doesn't live in a policy. Probably that doesn't live in a policy, but having a protocol for how these things are handled is essential.
Yeah, I always, I do all this public presentation stuff, and I stand up as a lawyer in the room, and I get to say on this particular issue all the time, engage your IT guy, empower your IT guy, deploy your IT guy. It is so much cheaper to have a decent policy and a robust IT practice than it is to hire Brian. Like it just,
Yep.
an ounce of prevention goes so far on the techie side. Because once the data's out, once the information is out, the trade secrets are out, you can't put them back in. The genie's out of the bottle at that point. We can go searching for damages, but I can't put the genie back in the bottle.
Yep.
As Natalie always says, the court is not going to protect your data if you didn't. You
Exactly.
can't go to a court and ask them to protect your trade secrets if you had them out there.
All right, I'm gonna hardcore switch gears. Okay, Amber, Brian, Lindsay, you guys are up again. Sarah, I've let you be so quiet today. I'll get you later. I'll get you soon enough. But I'm going to hardcore switch gears. I want to talk about things like NLRB, about civility rules, about social media engagement in 2026, about confidentiality thoughts in 2026. So hardcore switching gears. Uh, Amber, I'm going to start again with you. We have these common handbook clauses that call out things like civility and no negativity and have social media constructs in them. And they talk about really broadly bringing in confidentiality concepts. And now we assume or things are presumptively kind of risky under Stericycle unless they're really super carefully written. What are you thinking about with Stericycle in place about these sort of how people represent themselves in public in 2026? How are you thinking about it as our prevention person?
And I think to start out with, just because, some of these things people don't inherently know, right? And so, what is that? And it's basically looking at it from the employee's perspective. And so, whenever you're going through these policies, looking at it, could an employee reasonably read this policy as restricting a protected activity? Can the employer justify how the policy reads? And so, with those specific policies that you mentioned, those are definitely some of the ones I do look at in the beginning. So, civility, that's no negativity. A lot of people, I mean, I would love this too, right? No negative comments, have a positive attitude. You can see them discouraging complaints, anything that prohibits an employee having a complaint, you need to make sure there's not language. Might not perceive it that way, but again, look at it from the employer's perspective. And then social media, that's one that I really, really like to touch on because you have to be very careful how you do that. Not posting about the company, that's something you cannot say. Post must reflect the company positively. Things like that. So just limiting those, and then I'll leave confidentiality and the other two, but I think you get where I'm going with how I look at policies, and kind of navigating that
Let me
ruling.
pump back to you that the biggest, it comes up every election cycle, of course, and obviously, but like I always think this is really good framing for sort of the sum of it. Every single election cycle, we get employees marching into the workplace, mouthing off about politics, and they're like, "Nope, I got First Amendment rights. You can't tell me I can't talk about this, that, and the other." But what is it we say, Amber?
Nope.
I mean, it's not a thing.
I'm just like, it's very neutral. I like to say no politics, but just keeping everything, neutral with that, and just being careful how it's written in there.
Yeah. But then, Lindsay, you go and investigate the toxicity that brews when we have some of this stuff happening. Either you're coaching around it, sometimes bad actors, sometimes people dealing with it within their own workplaces, trying to grow beyond it. But then you also investigate allegations that come out of this incivility issue, people just becoming so disgruntled they feel motivated or called to be so uncivil or unprofessional on social media or off. And then we got some stuff saying that we can't be told to hush down. But when it comes down to the practice of identifying it and calling it out in the workplace through an investigation or even in coaching, how do you think about these things?
Yeah, I think what Amber said about not about being intentional about not discouraging reporting and not discouraging people from speaking up in terms of their concerns, like, right, it's different than speaking up about your personal opinions or speaking up about how you feel about different things, right? The policy really should center around like the regulation of behavior and avoid kind of vague language. Natalie, you threw out terms like uncivil and disrespectful and or maybe you didn't say disrespectful, unprofessional. And that doesn't, those kinds of terms don't say anything about the behaviors that might be associated with that. And so as a psychologist, I look at these things from like, and an investigator, I'm looking at behaviors. So what behaviors specifically would be classified as unprofessional or disrespectful. So making threats or acting in intimidating manners or, being physically, physical assaults, obviously. And so looking for those specific behaviors and specifying as much as possible or as much as is reasonable in a policy is really important so that there are no surprises for employees, if that makes sense. Because again, as a psychologist in this, I think a lot about, and we're going to head in this direction in a minute, but I think a lot about, the conditions under which employees are going to feel comfortable bringing their concerns forward. Because of course, an employer can only do something about that if they know about it. And they can't operate on rumor or gossip in effective ways. And so creating an environment where it's safe for employees to bring those concerns forward, whether they're valid or they're corroborated or not, is less important at that stage. And so it's really important that there's an environment where employees don't fear retaliation and don't feel intimidated about bringing those concerns forward.
Yeah, and I'm sitting here wondering, Brian, I'm going to get to you, but Sarah, I'm sitting here actually thinking about you in all this. You end up doing all of our mergers and acquisitions and our deal transactions. What do you think about when we have this, and I'm calling it toxicity for lack of a better umbrella phrase, but when we have this sort of toxicity in brewing, or like we're trying to do a big deal, but Bob's secretary is off on Facebook disparaging us, or we're starting to get complaints coming in because at the worst possible timing while we're trying to get stuff done. How do you look at some of this stuff based on a policy, based on a handbook, or just based on the fact of it happening when our owners and our C-suites are just trying to get the big deals done?
And it always seems to happen when those big deals are getting done. I would say,
Absolutely.
yeah, as part of your due diligence checklist before you even start thinking of merging or acquiring another company or anything like that, you need to get someone like Lindsay on board to do cultural assessments to kind of suss out like, hey, where are the skeletons in the closet? What cultural issues do we have to be concerned about? Are there people that are going to leave that are going to detrimentally impact the value of the company? And for some situations, like people may need to leave, but for others, whenever you have some C-suite executives that are real value drivers that are really critical for you to get the valuation that you want, you can entice them to stay with things like just different incentive and plans, and we can get really fancy with what those incentive plans look like, whether it's phantom stock or just some performance-based ownership type bonuses. And those are still possible even when you're in the merger and acquisition space, as long as, the potential person you're partnering with is on board too, and they see the value of that executive. So yeah, in a perfect world, you would know all this before you start having a merger and acquisition conversation, but we know that you're going to come to us and like, it's just, we'll have a way of surprising you. And we're more than happy to do the crisis management and kind of just suss out best on how we can control your situation based on what's going on. And yeah, it's no one size fits all for sure.
It's not. I'm going to use again employment law stuff verbiage now that I asked you as the sort of deal maker to weigh in, but the ROI on a people audit is outstanding. Just doing the check-in to see what's going on. Do we have our foundations in place? Is it actually landing with the real humans in the way we think it is? The ROI on a people audit before you go into a deal is just astronomical. Okay, Brian, so we've got the academics of it, we've got the socialization of it. We figured out it's only going to crop up during, a big deal trying to get done. But Brian, when it gets to be conflict based, what do we do when we have some of these issues flying around?
I guess, can you give me a more specific issue? Like, are we, yeah, you have a hypothetical.
Yeah, we recently had a threat assessment. Lindsay took us through a threat assessment, and so I'll just make an imaginary downstream activity here. Like, what if we had that guy that you guys dealt with lately in that threat assessment? What if he had been all over social media while Sarah's in the background trying to get a deal done and trying to be toxic? but you're having to use paperwork. Or we actually have another client right now that someone has gone out and socially just trashed a bunch of employees and is suing all the employees, but not the employers. I mean, that's the kind of stuff that starts hitting the courtroom, even though it's over in social mediaville.
Absolutely. I see where you're going with this. And, you know, sometimes there's just not a lot of legal solutions. You might be looking to get an injunction against your employee, to keep them from talking, but you can't prevent an employee. You can't put language in your handbook that would chill an employee's right to speak negatively about the company. And that really is a big change. Um, but I haven't seen it specifically come up where employees are making claims that their rights are being limited by a handbook. But what we have seen is really high chat GPT usage. So I would expect that it will be coming soon,
Yeah.
down the pipeline.
Yeah. Yeah. I wonder, or my thought in reaction to that, Brian, is that we are seeing a lot of that AI usage, and people are, getting their legal licenses through ChatGPT and other platforms, and cleaning up a lot of that is keeping us busy for sure. And I also think what you said about there not always being good legal solutions to problems like this is really important, because a lot of times people think like the legal avenue is the last resort, or is the way to solve a problem. And I mean, I think if Mary Beth were here, she'd be saying, let's talk about PR. Because really then it becomes sort of a damage control situation, especially in the circumstances in which the activity is unfounded or untrue or what have you. But they're using technology to disparage the company.
Yeah, and I think it goes back to the employee being disgruntled in some way. And that is really what you're not allowed to limit anymore. So it is almost a PR contest. I think that's a great way to look at it.
Yeah. All right. Let's totally switch gears and start talking about things like leave and scheduling and hair and protected classes. All right, Amber, this goes to the nuts and bolts of what you do. Sort of the grunt work side of the genius that is an Amber handbook program. Um, States and cities and counties and like we've got micro rules all over this country. And we primarily practice in jurisdictions where there's less of that. But places like California have down to like neighborhood rules. And it's insane. And so with all that, and they change all the time. And so it's fine when we have like a once a year federal change, but when we have city level and then county level and then state level changes all the time, how practical is it to have a single master leave section or vacation section or benefit section in a handbook versus having a jurisdictional addenda? We were just talking about what do you prefer one format over the other for this kind of thing. And I'll share, I have I'll take over the conversation because I get to because I'm the moderator. I have a handbook that I made for an employer that we had to deal with because they said that they were jurisdictionally agnostic in their employment, which makes me insane. Why would you do that? But I have used the index for their handbook as exhibit A of what you don't want to do when I'm reining in back other employers. Here is the 317-page handbook for an employer that insisted on being jurisdictionally agnostic. But okay, getting back to the usability and the nuts and bolts of how do you do it when we have people everywhere, Amber? What do you prefer in terms of formatting?
I absolutely do think a general core master section and having addendums. Some people, I mean, hire, You think because remote, especially, they will hire, they're only in Texas today, and tomorrow they're hiring someone in Colorado and South Carolina. You know, there's good talent everywhere. And so that just makes it so much easier to have that addendum because things do change so frequently. And it's not just leave, there's training rules now. Illinois, a lot of the states are doing training. So, I mean, it's really just, I feel like every state needs to be a little bit different, and it might not be a big change or it might not seem significant enough, but it's better just to have it in there if it is a requirement for that area.
So you like it as the addenda.
Yeah.
And then Sarah, I'm gonna punt to you. We always have, but right now we have a client with that is having a lot of jurisdictional issues. So they not only didn't have an addenda in their handbook, they're not registered to do business in most of the states that they're working in. And so talk to us about what that means in terms of having an employee that now has rights in a state that you're not allowed to appear in the court for.
Yeah. So this happens a lot just because people are focused on their actual business and growing and finding, the talent wherever it may end up. And so the keeping up to date with different state compliance, it can get away from you really fast. And sometimes, yeah, you'll find out about it as soon as you need to try to file the right things to appear in the proper court. The important thing is before you make a hire that's in a jurisdiction that you're not currently in, you need to look to see if you, based on like what's going on, if you need to register as a foreign entity in that state, pay the registration fee, set up your reminders, or have your attorney set up the reminders to renew that foreign registration, and then just keep up with all the different compliance. Find some local councils to make sure that you're complying with different laws that you may not know about because they're very jurisdictionally specific. And the main thing is just really have a good relationship with some sort of counsel so you can keep them up to date with your growth plans, and they can make sure that you do all the quote unquote boring parts very efficiently.
Brian, I was just thinking you have a client dealing with this right now too. It's an out-of-state client, and it doesn't matter, but they brought a claim in Texas for an out-of-state employer, and like now we got to do stuff. You want to talk through a little bit of that or some lessons
Yeah,
learned?
it's funny you asked that because I had written a note about that. And so often you don't think about the fact that you're an employer in that state and until you have a problem and the employee comes back at you, and you are not registered to do business. Sometimes we can fix that and register you to do business before something actually happens, but most of the time it's too late once the employee's made the claim to do anything about it. And so staying on the front side of compliance is really important because you may have a very strong argument that the employee's wrong, but you're not even going to get to make it until you pay all the taxes that you were supposed to pay and do all the other things in that state that you were supposed to do. And you're going to be facing the fact that the court's going to look at you as an outsider.
Yeah, all of that, and then now you're a Texas employer. And so then we have to get a Texas handbook, and then we have to socialize it in Texas. I'm pointing at you like anybody can tell where I'm pointing. Um, but yeah, I mean, you can do it in advance or you can do it in the emergency. So think about it ahead of time. All right, Lindsay, there's so much fun socialization around crowns, and I got to get my crown straight. And I say get my crown straight all the time, and I got to get my life together. I got to get my crown on. But that's not what we're talking about in the employment section or employment space. And Lindsay, you and I were working an investigation when this came down in Texas, and Texas adopted it kind of before it got mandated sort of everywhere. But Amber, we got princess issues now. We got to get our crown on straight. Talk to the universe about what it means to have a Crown Act issue and what we do with that through our policies and handbooks, and then we'll punt over to Lindsay about socializing some of that stuff. And it's not just crowns, right? It's what do we wear? It's all the rest of it.
Russian issues.
Crowns and robes, maybe.
Yes. Okay, so yes, I think just crafting this very carefully to make sure, because you don't know what you don't know. I actually did a training on this, a DE&I training a couple years back, and I'll be honest, I went and I talked to people, and I don't know what I don't know, right? And so I think educating yourself, educating your managers on what I'm about to tell you, because you don't know when you're offending someone or when you are, getting close to someone's culture or religion or whatever it may be. So basically, the Crown Act says that if it doesn't have to do with a job's function, safety, operational needs, that saying certain things in the policy like professional, neat, unusual, extreme, those words that are really a little bit more subjective. So you need to allow natural hair textures, um, only apply restrictions, like I said, when it's job related, when it's safety based, consistent enforcement, which again, I know we keep mentioning this, me and Lindsay especially, but training managers on consistent, because you don't want to have someone, be able to do something in one department and not in the other. And then, hygiene, safety, those kind of things, but really just focus the policy on that. I think a lot of outdated policies kind of use those words, and you just really need to update those if they still say anything related to subjectivity.
Yeah, and I think sometimes people just get so awkward about it.
Yeah.
Um,
Doesn't have to be.
it doesn't have to be. So talk through somebody trying to do the right thing but being so awkward, or just not even knowing that they should be doing something, or being terrified of saying anything at all. Lindsay, talk to us about socializing it.
Yeah, I think that, and Amber touched on a lot of the things that are on my mind about this. But and handbooks are a little bit tricky, right? Because in some ways you want to be really explicit about the right behaviors and the wrong behaviors, and in other ways you want to be as general as possible so that it can apply across multiple jurisdictions, or that it's not prescriptive in nature necessarily. But really, when it comes down to culturally sensitive matters, I think being more explicit rather than less is and doing away with the ambiguity that sometimes creeps into policies and enforcement is really important, because if you leave the door open for too much managerial discretion, especially if you haven't trained them and educated them appropriately, is where you're going to get is what will give rise to complaints that we end up investigating, right? So it's managerial discretion sometimes results in looking like selective enforcement, which sometimes can have an adverse impact on certain protected groups. It can look like inconsistency that is very clear to employees and how they receive that. And so I think that policy language is really important here in order to head off any potential complaints that may come about because managers are not enforcing the policy properly or consistently.
Yeah. Brian or Sarah, you guys got anything to add on that?
I was gonna say, and it's not really about the crown, but Lindsay brought up a great point, is that when you have different managers doing different things, it really is hurtful in the litigation context, because you're not able to show that you treated everybody equally. I think a really clear example would be like one manager that doesn't do annual reviews, and the employee gets terminated, and they're saying, oh, this other person had the same job, but they got an annual review and I didn't, so I didn't get an opportunity to improve, and they did. And you're maybe having to settle that case for a higher dollar value than you would otherwise.
Yeah. All right, I'm going to transition. This next question, Amber, feels so poignant right now. You and I are working through an issue. We have an employer. They have a fantastic handbook. We wrote it. And, and then we found out that they have hundreds of policy documents we didn't know existed. And those policy documents, I don't know if they're from France or some country that is not very much like not like Texas, at least, where this employer is. And so we have this situation where we have some really good investigations verbiage in a handbook. We have a past practice of having a really good practitioner come in and do some really solid investigations for them because we did it. And then we find out they're in this horrible situation with an employee, and they have this investigations policy that is just over the top. It gives employees rights that no employee should ever have. It lays out an administrative proceedings or procedure for all these things that you have to do that could not possibly be done in an emergency investigation situation. We, Amber, and I'm going to punt you to make other comments about how we could have done this better. But we actually recommended not doing a formal investigation because they had gone off and made these policies about their investigations that literally could not be adhered to. But we got the civil rights obligation too. So Amber, you want to talk a little bit about, like, again, we're dealing with this engagement between policies and handbooks, but also what do you put in writing in either a policy or a handbook about the way we're going to do investigations? And then Lindsay, I'm going to ask you, what do you do when we get given stuff that's so far outside of our typical practice?
So I think having a single source of truth, I mean, that does happen, but I think that is the most important because a lot of times people just sometimes like to create policies and they're like, oh, we'll just have this policy and this one floats around. And then you end up having all of these that you don't know. And so having that single source of truth. And so, we're going to go through once we found this out and I'm starting to do this and look at all of these policies, what policies need to be folded in, what does not, and then retire them. Don't just make them go away or anything like that. I think communication is key with these things. And, if you're editing handbooks, so I get a lot of questions about that too. How do you make sure you're dating it, you're logging what you're changing, you're communicating, all of these things. But having, I think the biggest thing is source of truth. And then I think you asked about investigations as well. So like I just said, you can't just say, oh, we're not going to follow that policy and we're going to do this one. So you have to adhere to it and then just act quickly, to try to figure out what can happen when these things come up and deal with it. But yeah, I'll pass it over to you, Lindsay, to kind of take
Yeah,
it from.
I love that single source of truth because Lindsay, we have a solid investigative practice that we hang our hat on from this firm so that we can always go to a court and say we have done this in every single instance. Now it is our pattern in practice. Now you have to prove we did it differently in your case. Not that we don't accommodate our clients having specialized stuff. Like, our practice lately is not to record, but if you have a workplace that insists on recording, of course we're going to do it for you. But Lindsay, what do we do when we have a client that desperately needs something investigative? We have a federal obligation to investigate, and then we have all this stuff that's coming in either as an employee expectation of how we should do our jobs or some written document.
Yeah. I think what we're really talking about here is the distinction between policy and procedure. And I'll add another P to that, and that's practice, because sometimes the practice doesn't comport with the procedure, right? And so the policy tells us and all our employees what the rule is. The procedure tells us and the specific employees responsible how to comply with that policy. And then the practice is how it's done in the real world. And in the best case scenario, all of those things align. All of those things can act as a source of truth. And really, as the psychologist on the team, I always come back down to behaviors, right? And how do we make sure that the behaviors comport with the policy and the practice, the policy and the procedure. And so we really do have to be thoughtful when a client is asking us as the third party vendor to deviate from what is our normal practice and what is our protocol for handling investigations. And so long as we can reasonably justify why we would make an exception in that case and document it, we are happy to have those conversations with clients. What I find actually happens more often than not is that our clients are happy for us to follow our standard practice, because that is the thing that will be defensible for them. And I don't know, maybe Brian has just different perspective on that, but that is the thing that will be defensible for them. And so we don't actually find, I at least in my experience, don't find a lot of clients digging in hard on their own practices and asking us for a deviation when they've specifically hired us as a third party for many reasons.
Yeah. What do you think, Brian?
You know, I think I agree with what Lindsay is saying. The clients do generally benefit by sticking with um, our practices. And from a litigation perspective, the investigation, whether you're following general rules or the way we do things, you want to keep it consistent and make it so a jury would find it to be sufficient.
And actually, Natalie, your example that you gave about the recording piece actually just came up in a recent case that I thought might be beneficial for me to talk about briefly. And that is, we had an accused party who insisted in our initial meeting, in our attempt to interview him on recording the interview. It is not the practice of our firm to record, and everyone else who had participated in the investigation up to that point had followed our practice. We did not record any of the interviews. And so it would have, even though it may have been the client's policy and it's legal in the state of Texas for recording, even though that may be the client's policy or practice, it would have been a disservice to the consistency of our practice and our investigation when all of the other employees did not have the same opportunity to record their interviews. And so we had to insist on following our practice in that case. And our client was happy for us to do that.
Yeah. All right. I'm going to change gears again. Let's talk about cannabis.
What a transition.
Well, after all that, people might be thinking about cannabis anyway. All right, Sarah, what are you seeing as far as cannabis go? You work out of Texas, you live in Wyoming, you do stuff everywhere. You have looked at international financial transactions. Talk to us about cannabis deals.
Yeah. And I used to be part of the cannabis section of another firm too, to advise like those startups. And the main thing that you always see when cannabis comes up is everybody's confused. You have a federal law that says no.
Well, that's the thing about cannabis, right? Everybody's just confused, man.
Confused, need a pizza, you know. Um, and then you have like even in states where it's illegal, you have some medical marijuana laws. You have the gummies where if they're under 0.3% THC, they're generally fine in most places. So people are doing cannabis. Big surprise there. And now it's how does it impact the workplace? So you have specific places where like where safety might be involved, or you have like the people that are on the synthetic cannabinoids, but they'll still pop on a drug test. And so you'll see a general point of confusion just with different businesses on how to handle drug tests, what the implications of those drug tests are. Are you going to be requiring documentation for people that are using medical marijuana? Like lots of people, they'll just have very vague policies that says something along the lines of like, don't show up to work impaired. But then you have impaired can be a very subjective definition. Like what counts as impaired? You know, if someone pops a gummy before work or they use the synthetic cannabinoid where they're not high, but they'll technically pop a drug test, where is the line? And a lot of times you'll see people use these policies to just be militant towards certain employees that they have other issues with. So they're like, if they know they'll pop on a drug test, they think that's the easiest way to get back at them. But impairment outside of work, like why should we really care about that? So basically it's a really big gray area, and you should really talk to somebody before you just start enforcing very vague and subjective policies, and inspect some pushbacks when you do.
Yeah, you know what else I'm thinking about, Sarah, is the time we walked through federal defense documents with people that we knew had been to Lindsay State in Colorado. And then there's, all this issues, well, under that ag exemption, some of this is okay, or I was on vacation 2 weeks ago. That's why this is happening. But when you start looking at these federal and defense issues, now we're international, and money is color of money is international, it's federal, it's state, and it just gets even more complicated. Uh, Lindsay, anything that you're hearing locally in Colorado about, I mean, you still can't use a credit card, even in Colorado,
True.
to take a withdrawal. Like it still has weird consequences, and we bring it into the workplace. too, and then we're gonna hit Amber about what do we do then? But what are you seeing
Yeah.
locally, Lindsay?
Yeah, I think that Sarah was so right to hit on the notion that like everyone's confused because there are a lot of nuances here. I mean, we can maybe draw a bright line around and building parameters around what impairment means in our organization and how does that get crafted into our policy language. And I'm sure Amber will talk more about this, but there are a lot of subtleties that flow from legal cannabis usage. And I just read a post the other day in one of the HR groups that I'm in. It was a childcare facility that had lockers for their staff members that were kind of in open areas, not necessarily like a dedicated locker room. And the smell, whether or not someone had cannabis in their possession, the usage of cannabis outside can actually come into the workplace. And what are the implications, and I don't have an answer to this, but what are the implications in that kind of setting of just bringing that to work with you, not directly but indirectly, and how does our policy and our practice accommodate for that, and what's reasonable and what's not reasonable, and what safety hazards might be posed or not, as a result of these like subtleties that are actually really playing out that I think a lot of folks don't know how to handle. And then you have, I'm always thinking about the culture side, the employee side of this, and how do you make explicit what the expectations are when it's hard to anticipate what these downstream impacts are.
It's all right, Amber. So how do we not get in this situation? How do we not tee Brian up to have a really expensive case where we have inconsistent case law to fight through?
I think understanding, locations where you're at, this comes out up a lot for me with multi-state employers. And so when it's allowed in one state, not allowed in another, and then how you're going to handle that. And really making sure and it comes up a lot as well on backgrounds. So when you're running backgrounds and pre-employment, and that's where I really get a lot of questions as well. And in those cases, not just blanketly, like we've said, not blanketly saying, okay, it's not allowed. And again, knowing what roles they're for. And if someone does come up positive for that, how to handle that. So whenever you're looking at it, what role does the employee hold? Is it a safety issue? What state and federal law comes up here? Looking at those. I know I keep repeating myself on that, but making sure and then was it an impairment or a safety issue? And so I think there's kind of a lot to unpack on that, but I mean, just from start to finish with employment, it's definitely important to make sure you kind of know the laws there and what the policy is for the company.
Bring us home, Brian. If you're
Yep.
comparing state laws, it's infinitely interesting to a litigator. But if your litigator's interested, your client is spending money. So bring us home.
I agree with that. And one thing we kind of haven't addressed is where the ADA meets this marijuana law. And, you, if you think somebody has used marijuana off the clock, do they have a prescription? And you're also kind of wondering, am I perceiving them as disabled when in fact they're not? And so on that impairment issue, someone might not be impaired and they have a disability and you accuse them of being impaired. That can be a huge problem for you.
Yeah.
Not to mention the drug testing issue of you can't really prove if someone is
Right.
impaired or not impaired at that moment because there just isn't a test for that.
Right. All right. Go ahead.
The one thing I was to say is if you have crafted thoughtful policies that are based on safety and not directed at the actual usage, you're probably better off.
Yeah, absolutely. All right. Well, with that, we'll wrap it up. Thanks, everybody.